Hi, my name is Ewan McGahey, and today we are doing competition law through the lens of enterprise law. And we're going to try and cover the whole of competition law in a bit over an hour. So, the idea that I want to start with today are the foundational concepts that Adam Smith gave us on how a competitive market economy worked. Adam Smith is well known for the metaphor of the invisible hand. And the first time that he used this metaphor wasn't in his big magnum opus, The Wealth of Nations, but in his book, The Theory of Moral Sentiments. He said the rich consume little more than the poor, and in spite of their natural selfishness and rapacity, though the sole end which they propose from the labours of all the thousands whom they employ, be the gratification of their own vain and insatiable desires, they divide with the poor the produce of all their improvements. They are led by an invisible hand to make nearly the same distribution of the necessaries of life, which would have been made had the earth been divided into equal portions among all its inhabitants, and thus, without intending it, without knowing it, advancing the interest of society. So, there's a mixture of ideas here. One of them is what we might call today trickle-down economics, that because the rich can't spend everything that they take in income, they will have to distribute the amount of money that they have, the excess money, to people that they employ. And paradoxically, though they're just following their own interest in doing so, says Smith, they end up distributing wealth as if the earth had been divided into equal portions. So this idea of the invisible hand in Smith's concept was the idea that when you let the markets work freely, then you end up, or you get to a tendency of equality. Now, Smith was very much more nuanced and different when he writes The Wealth of Nations. He uses the metaphor of the invisible hand in another passage on trade between countries. But he starts to see something very different from what he's envisaged before, and particularly sees economic organization as being good when it's based on small partnerships and bad when it's based on large corporations with a lot of power, particularly monopoly power. So another famous passage from The Wealth of Nations, he says, it's not from the benevolence of the butcher, the baker, the brewer, the butcher, the brewer, or the baker, I should say, that we expect our dinner, but from their regard to their own interest. And that is the famous idea that these small partnerships, the butcher, the baker, the brewer, when they act under competition, they paradoxically, though they pursue their self-interest, act in the public interest when there is a constraint of competition. Smith, throughout The Wealth of Nations, castigates big joint stock corporations. He says in another passage in chapter 10 of book 1 that the pretense that corporations are necessary for the betterment or the better government of trade is without any foundation. And as we've seen before, he says that directors of joint stock companies, because they manage other people's money, are prone to negligence and profusion. So Smith's ideal was small competitive partnerships bad, big corporate monopolies, I beg your pardon, small competitive partnerships good, big corporate monopolies bad. And so this idea of the invisible hand and the tendency to equality really for Smith is based on the idea that we are living in a market society where there are small competitive partnerships. The tendency towards equality that the market should do is only really existing for Smith when you have competitive small and medium enterprises, not big corporations. Now, Smith also goes on to say, and there's lots of different passages that we could pick on, but that monopoly, for instance, in particular, is the great enemy to good management. And so this idea that monopolies were bad runs throughout political economy through the end of the 18th century, throughout the 19th century, and really through most of the 20th century, and still today, except as we'll see, it's much debated by certain economists and certain lawyers. John Stuart Mill famously writes in Principles of Political Economy that wherever competition is not, monopoly is. A monopoly in all its forms is the taxation of the industrious for the support of indolence, if not plunder. Monopolists rip us off. Monopolists make the economy sluggish, the support of indolence, not industry. Okay, so when we get to the development of a proper competition policy in the early 20th century, particularly beginning with the Clayton Act of 1914, which strengthens the very defective initial provisions that there are in the Sherman Act of 1890, and the Franklin Roosevelt government comes in and strengthens competition enforcement and creates extra prohibited categories of abuse by monopolies, particularly price discrimination. The formulation, the concept behind competition law becomes what is expressed in the 1944 State of the Union address by Franklin Roosevelt, right at the end of his presidency before he dies. He said that there should be a new economic Bill of Rights, and included in this Bill of Rights should be the right of every businessman to freedom from unfair competition and domination by monopolies, whether at home or abroad. And you might think that human rights is pretty distant from the workings of competition and competition law, but actually we see that when we come to economic and social rights, it's critically important, and also it's critically important to the survival of democracy. So when we look at the European Union Charter of Fundamental Rights, we see two main human rights that are related to competition law. Firstly, the freedom to conduct a business, so that's pretty much echoing what Franklin Roosevelt says in 1944, and that there should be a high level of consumer protection. So, quite similar to labour law, which foresees a group of minimum standards through which no worker can fall, and then the set of rights to have voice, to get fair terms beyond the minimum. In competition law, we can see a similar kind of system when we put it together with consumer protection. Consumer protection creates a baseline so that consumers don't have unfair terms. There have got to be minimum standards. And in competitive markets, consumers should be able to get fair terms, good quality products at fair prices through the workings of competition. And as we're going to see, and of course what most of enterprise law is about, where competition doesn't work, we substitute public regulation and public ownership of enterprises. So that is generally the direction in which progressive thinking in America and Britain and the rest of Europe has moved. And what we've just described so far is still pretty much the main paradigm of thought in countries like the UK and the rest of the Commonwealth and in the European Union. But when we go over the Atlantic to the United States, we can see a critical split opening up in antitrust law. Progressive thinkers in antitrust or competition law in America, the Americans call it antitrust because originally a cartel was known as a trust, and busting the trusts became called antitrust. Same thing as competition law. But in the Americas, in the United States, there was a split where, particularly in the University of Chicago, from the post-war period, it was relentlessly argued that antitrust needed to be constrained. And actually, it was the law that was the problem, and corporations should be free, more or less, to do as they pleased. So a foundational book, it's called The Antitrust Paradox by Robert Bork, where he argues that competition law shouldn't be about sort of multiple goals, protecting the public interest, certainly not, protecting the environment, God forbid, protecting workers, certainly no, protecting small and medium enterprises, definitely that should be ruled out. Bork argued that the only legitimate goal of antitrust is the maximization of consumer welfare. And pretty much the year after he writes this, in 1977, to go to 1978, the US Supreme Court and the Republican appointees on the bench appointed by Nixon, Ford, and so on, they adopt wholesale the prescription of Bork and say that antitrust rules are a consumer welfare prescription. And slowly you see this descent and the inversion of the original purposes of competition law, which were against monopolies. to be only about trying to protect consumers and ignoring the very much bigger picture of protecting small and medium enterprises from abuse by large monopolies, of controlling monopoly power, and ultimately the protection of democracy. At the end of the 19th century, when the American legislation in the Sherman Act and the Clayton Act in 1914 was passed, it was explicitly about controlling the big monopolies that had developed, particularly Standard Oil. We're going to see a bit more about that later, because it was seen as being a threat to representative government. No more of that. In 2004, Justice Scalia, one of the most extreme right-wingers on the Supreme Court, argued that monopoly power and the concomitant charging of monopoly prices is not the antithesis to the competitive free market system, but is an important element of the free market system. And we see this idea summed up by monopolists today, notably Peter Thiel, who's one of the early backers of Facebook, one of the founders of PayPal, a big investor in Palantir, a big backer of Donald Trump and the sort of big tech oligarchy that sits around him today. He writes in 2014 in the Wall Street Journal that competition is for losers, and the best strategy that should be employed by businesses that want to be successful is to find a monopoly and hold on to it, and the law shouldn't do anything to challenge that kind of corporate power. So there are two completely incompatible views in the theory of what competition law should be doing. What we're going to go through in this talk is the framework of competition in Britain and Europe, and how it is definitely not the perverted concept of antitrust that we see in amongst thinkers like Scalia and Bork in the United States, very much still with the traditional ideals, but nevertheless under a great deal of pressure because of this relentless drive by big business to protect their monopolies. So firstly, we're going to look at the framework of fair competition. Secondly, we're going to concentrate on the control of monopoly power, or more broadly, as we call it, dominant positions and the abuse of dominant position. And we're going to see how the law controls mergers and takeovers, which could lead up to a dominant position. Thirdly, we're going to look at the law on cartels and more widely collusive practices. And fourthly, we're going to look at the control of state involvement in the markets and the rules for controlling state aid. Okay, so let's start off with the framework of fair competition. Firstly, the minimum set of rights for consumers that are set in the law. Secondly, the scope of competition law, and mainly that's about the definition of an undertaking in EU law and UK law. Thirdly, the rules on enforcement. And fourthly, the taxes that apply in relation to consumers or consumption, namely value-added tax, or in particular value-added tax. Okay, so first we need to start with the framework for fair competition. And I think it's important to see that the goal of competition law in EU law, which is identical to UK law, is to prevent competition being distorted to the detriment of the public interest, individual undertakings and consumers. Okay, so already we can see that while competition law is partly about consumer welfare, it is also, looking at the broader picture, about protecting small and medium enterprises, individual undertakings, and the public interest, ultimately. So it's not Bork's view, it's not this narrow concept of a single value for all of antitrust. We're looking much more widely. And I should just mention that although, the UK has obviously left the European Union, UK law is almost identical to EU law in all of its competition law provisions because of the intertwined history. And in fact, some of the best European competition lawyers have come from the UK. So the development has been together, and Brexit hasn't really changed any of this. And so that's why we're going to focus on EU law to understand UK law. Why would we want to protect consumers in particular? So why do consumers need to be protected? Why not have just freedom of contract and totally free markets without any statutory rights? And I think the answer is pretty similar to the reason why there's statutory rights for investors or for workers. First is that consumers have unequal bargaining power vis-a-vis businesses who they rely on for goods and services. So we see that coming up across in multiple cases, particularly Courage and Crayon that we're going to come to a bit later. Consumers have systematic asymmetries in information. They lack as much information in negotiation compared to the businesses with whom they bargain. And consumers often act irrationally. So that doesn't mean that people are stupid, but consumers, like all human beings, like me, like you, often operate as if we've got two systems of thought. We have a slow, deliberative system of thought, and then we have a quick thinking system of thought that we use for sort of everyday snap judgment. So if I go to the supermarket, do I take the 3 for the price of 2 offer? I might have a rule of thumb and apply that, even though it might not always be in my financial interests to do so. There are many, many different ways in which human beings are rational. The endowment effect, the status quo bias. We've talked about these before. It's what has stoked or given rise to the field of behavioral economics. And so because of this, competitive markets often fail to work in the consumer interest. So that's why we have consumer rights and we have also public regulation. And I think one of the good ways to understand how all the consumer rights fit together with competition law comes from a speech by John F. Kennedy in 1962, sort of echoing Roosevelt's second Bill of Rights, social and economic rights. He said there should be a Bill of Consumer Rights too. And JFK isolated 4 different rights. Firstly, he said that consumers should have the right to safety. So under the Consumer Protection Act of 1989, which comes from the EU Product Liability Directive, you have a right against defective products. So if you buy a toaster and the toaster explodes and you get hurt, you can bring an action against the retailer and everybody, the wholesaler, the manufacturer, and there is strict liability. To this, sort of basic rights like these to safety, we can add essential rights of consumers to satisfactory quality of products and also the control in unfair terms. And we could do a whole session on this. Most courses on contract law will deal with a little bit of consumer protection. We see those rights in the Consumer Rights Act of 2015. There's the Unfair Contract Terms Act that says businesses can't exclude liability for negligence when it results in personal injury or property damage. They can't exclude basic implied terms from the Sale of Goods Act. And we see many of these same ideas reflected in the Unfair Terms and Consumer Contracts Directive from 1993 in the European Union. Okay, so first set of consumer rights that form the sort of minimum floor, the right to safety, to satisfactory quality, and the control of unfair consumer contract terms. Second right that JFK said should exist is the right to be informed. And so we see this again in the Consumer Rights Act. Just to take one example, if there is a description given of goods that are being sold to the public, the good has to match the description that is given, so people have adequate information. We see a whole raft of similar rights in the Unfair Commercial Practices Directive. Third one, most crucial for us, is that JFK said there should be a right to choose from a variety of products and services at competitive prices. But where competition is not workable and government regulation is substituted, there should be an assurance of satisfactory quality and service at fair prices. So very basically, the first half of what JFK was saying there is the domain of competition law. When markets work, then competition law should ensure that there aren't monopolies and cartels to keep the competitive process alive, and the result should be a variety of products and services which are hopefully good quality, but at competitive prices. But sometimes competition fails for all sorts of reasons: natural monopolies, systematic unequal bargaining power, all the macroeconomic problems that we looked at when we did theory, and then you get government regulation, and I think we can add public ownership. And the goal there should be fair prices, but we also know it could also be goods and services free at the point of use if that is the more efficient way of running the service. Okay, so that's the third thing. And the fourth thing that JFK says is that consumers should have a right to be heard. And we can extend this idea, excuse me, we can extend this idea to rights of enforcement. So now let's just go to the right to choose and see how that maps on to the scope of competition law. So the place or the subject of competition law and the duty holders in competition law are undertakings, the actors subject to special duties against abuse of a dominant position and special duties to not engage in collusive practices like a cartel cover undertakings. And so if you're not an undertaking, then you don't have duties in competition law. And so very simply, the definition of an undertaking from a case called Höfner and Elsa Macrotron is that an undertaking is an economic entity which is engaged in an entity engaged in economic activity. So, the main idea there is that we're not looking at people engaged in social activity. And so the Court of Justice in the European Union has trod a sort of tightrope to try and draw this line between what it wants to catch in the scope of competition law and what should be left to a sort of different regulatory domain that competition law does not need to address. So first case that we want to look at, or after Höfner and Elsa Macrotron, is called FNV Kunsten, a case about clarinet players in the Netherlands. And so here the Dutch competition authorities, unbelievably, had brought an action against a trade union for clarinet players who were described by their employer as being self-employed. And the Court of Justice held that the Dutch clarinet players, or what the national courts had to do is they had to look at whether the Dutch clarinet players were really workers or were really employees rather than self-employed. And if there was sham self-employment, then their union would obviously be outside the scope of competition law. And this got a lot of labour lawyers very worried because it suggested that even if they had been self-employed, that a union of them could have been considered an undertaking, or that self-employed people could be considered to be an undertaking and therefore within the scope of competition law. So there's still an ongoing debate. The European Union acted afterwards to make rules saying that self-employed people can collectively bargain, incredibly important. And when we look at the treaties on the functioning of the European Union, it's very hard to see how self-employed people could ever be considered to be within the scope of competition law, to be considered as undertakings, because Article 49 expressly distinguishes between self-employed people on the one hand and undertakings on the other hand. And a labour law piece of labour law legislation, Transfer of Undertakings Directive, says that an undertaking is an organised grouping of resources. So if you are just a self-employed person without anything more, then you can't be an undertaking on a plain reading of the treaties. If you're registered as a legal practitioner, maybe you can because of the registration. If you are a single person who incorporates a company, then that's different again. But international labour law is in no doubt that self-employed people have an unfettered right to organise, collectively bargain and to strike, and competition law would fundamentally threaten those basic rights in international law if self-employed people were within the scope of competition law. Okay, but so that's the first thing. As a basic principle, workers and trade unions are completely outside the scope of competition law. Second thing is that a corporate group is not in its internal dynamics within the scope of competition law. So if you have a parent and a subsidiary and they make an agreement, that agreement will not be counted as unlawful collusion or a cartel because the relevant actor is considered to be a single economic unit of the corporate group rather than the individual legal units, the separate legal personalities of the parent company and the subsidiary company. And so we get that from a case called Vio. And we also see in another decision called AXO that what counts as a single economic unit is when a parent has decisive influence over a subsidiary. Third set of cases, illustrated by a decision called Vernin, is that if you've got entities which are based on the principle of social solidarity, as in the case of the Spanish Health Service, then these are not pursuing economic activities and so aren't considered undertakings within the meaning of the law. So that's very important to make sure that something like the Spanish National Health Service, which provides healthcare free of charge and aims to cover everybody with universal service, with universal cover free at the point of use, is not subjected to competition law, so that the service can be organised as efficiently as possible on the basis of cooperation. Funnily enough, the UK Health and Social Care Act of 2012 applied competition law to the National Health Service when it entirely didn't need to. A much better approach, much simpler approach, would just be the bright line rule which you see in the United States in a case like the US Postal Service decision in 2004 that says that government undertakings are entirely outside the scope of competition law. Now, thirdly, we've got enforcement, and we'll just say a tiny bit about value-added tax and other duties or taxes on consumption. So the basic ways in which competition law and consumer rights are enforced are through private actions or public enforcement through government agencies. In the UK, the Competition and Markets Authority. At the European Union level, that's the European Commission. So starting with consumer rights under Section 71, for instance, of the Consumer Rights Act, you can bring a small claim if you go to moneyclaim.gov.uk. You want to say that a business has subjected you to an unfair contract term, and you could bring a small claim and it's designed to be cheap. The Unfair Terms in Consumer Contracts Directive requires that all member states have mechanisms for effective sanctions against breaches of consumer rights and also provide consumer groups with the ability to make joint representative claims. The Competition Damages Directive requires that there's a right to full compensation for private actors for breaches of competition law, and a case called Courage and Crean represents or illustrates how a private enforcement action can work. This was about a pub who was tied to its brewery. It went insolvent. The vertical restraints, the beer ties, were decided by the Court of Justice to be an unlawful vertical restraint in violation of Article 101, the provisions on collusion. And the point that we're interested in here is that even though the pub was a party to the collusive practice, the illegal practice, because it lacked bargaining power in the relationship, it could bring a private enforcement action for damages against the brewery, and it could succeed in a claim. So that is an example of a private enforcement mechanism. But you don't just want to leave this to private parties, so we have public enforcement through government bodies. The Competition and Markets Authority can take complaints for breaches of consumer rights from consumers, and it can also bring injunctions against the use of unfair terms. And it hears more broadly, or it decides cases on competition law violations for monopolies, unlawful mergers, and collusion. So we find its powers in a range of acts of Parliament, the Consumer Rights Act, the Enterprise Act 2002, and as I mentioned, in the European Union, it's the Commission which is in charge of enforcement of competition law at the highest level, control of mergers, monopolies, and cartels. Finally, value-added tax. So the Value-Added Tax Directive in the EU requires a 15% minimum rate across the European Union. In the UK, value-added tax is 20% on most goods, but there are lots of exempt categories for things like healthy food, water, books, homes, transport, medicine, clothes. And then there are higher taxes than the standard value-added tax rate for sort of bad things that are harmful. Tobacco, alcohol, polluting petrol and diesel, and there are also extra duties under the carbon price support mechanism. Okay, so that's the basic framework of competition, of fair competition, and next we look at dominance, abuse, and merger control.